Hello everyone. I'm going to give it a couple of minutes for people to come in the room. Say hi, Bernice. Hi, Kimberly King Garrett. Feel free to share this on your social media platforms. Hi, Dr. Ryan, Professor Ryan, how are you? I wanted to come on and talk about A Tale of Two Autopsies. A Tale of Two Autopsies. Now, I am not going to be before you long, but I do want to talk about the autopsies. I don't know what it is, but it seems like every time I have a nap, something happens legally, and I literally wake up to it. So I wanted to just kind of give a brief explanation of what is going on, because of course you will hear a lot of commentary, legal commentary, as it relates to the fact that there are now two autopsies for the murder of George Floyd. Now remember, in the last video I told you that I believe that the reason why oh, you can barely hear me? Okay. Let me know if you can hear me. Can you hear me now? My voice was low. And I'm tired. So I apologize. Can you hear me now? Now? Can you hear me now? Can you hear me? Can you hear me? Can you show some hearts or thumbs up if you can hear me? Maybe if I bring the phone closer. Is that better? Can you hear me? Can you hear me? Let me know if you can hear me. You can hear me now? Okay. I was talking low because when I tell you, I just literally woke up for a nap. That's my self-care. So, I will try again. Yeah, I don't know what to tell you. Maybe log out and log back in because I can't get any louder. Otherwise, I'll be screaming. Okay? I see some hearts. People say that you can hear me. You can hear me. You can hear me. Okay. All right. Thank you. All right. So I will talk louder then. First of all, good afternoon. I am Natasha Robinson, and last week I did a live video, a live class, really, to talk about the case of George Floyd, because I had been getting so many texts, so many inboxes, so many emails, so many calls about that particular case. And so I said I was going to have a class last week just to kind of explain everything. Well, while I was sleeping, there was an independent autopsy that was released. The family of George Floyd, where there are two major developments. The first major development is that now the Minnesota Attorney General has taken over the investigation of the case, or the prosecution of the case, and there has been an independent autopsy conducted. I will speak to those really quickly because I said I was not prepared to come on live, but I believe that it is better to get the correct information, and I am going to go from my mind because I have nothing prepared. I will go from my mind as well as my experience, with the caveat that I have never practiced in the state of Minnesota. So a lot of my explanation will be parallel or aligned to what I think legally is going to happen. All right, so the first piece of information, that the Minnesota Attorney General is now taking over the prosecution. Is that a good thing? That is what people have been asking me. My response is, it depends. It depends, because although it is good to have an independent prosecutor, someone who is not engaged in the daily or routine activities of working with Minnesota police for prosecutions, it is a good thing because maybe that office is able to be more objective in its findings and in the prosecution of Derek Chauvin, and hopefully the remaining 3 officers. All right. Is it a slam dunk? Absolutely not. And the reason being, and I talked about this with my colleague Miriam Ahmad, that just because you have an independent prosecution does not necessarily mean it's automatically going to be a win. And we know this because of the case of George Zimmerman, who was killed. I'm sorry, I won't really speak that into existence. Who did kill Trayvon Martin in the Florida case. If you remember that, they had prosecutors in that case. I can't remember the name of the prosecutor, but what I can remember is the prosecution was doing the defense's job. That I remember. I remember that when I was watching that trial, I was a little confused about who was the prosecutor and who was the defense attorney, because the prosecution in that case did the bare minimum in trying to bring justice for Trayvon Martin. And so in this case, I am hoping and praying that the Attorney General's office prosecutes to the fullest extent of the law, and that they could possibly review the evidence and then decide to raise the charges. Okay, so maybe go higher with 2nd degree or 1st degree. Is that likely? Anything's possible at this point, because the prosecution is moving at light speed. They are moving at light speed right now to try and get this process going. The other thing that you need to know is, just because charges have been brought against the officer, and just because there has been 2 autopsies, which I'll get to in a minute, and just because there has been a change from the local prosecution of Hennepin County to the Minnesota Attorney General, that does not mean that this murder case is going to move at rapid speed, because generally speaking, murder cases take on average, at least a year. At least a year. And I'm speaking on the state and the local level. Now, does that mean that they can speed up really fast and prosecute this very fast? Absolutely, they can. But remember, we do not want a speedy case. We want a case of excellence. We want a case where every piece of evidence has been reviewed, that it has been cross-examined, so that we can kind of know in advance what the defense is going to assert. We do not want a quick case. So yes, we want justice right now. Absolutely. But there are still many documents, many videos, many statements that need to be reviewed, including the autopsies. Now we'll get to the autopsies. You have 2 autopsies. The first autopsy said that George Floyd did not die of asphyxiation, but he died because there was a combination of effects. The combination of effects was his heart disease, the fact that the officer placed his knee on the neck of George Floyd, and, quote, possible toxicants, which when we talked about last week, we were saying that you can infer that there was already victim blaming or victim shaming. Because if a toxicant is possible, why are we even bringing this up? First of all. Secondly, if it's a preliminary report, why not wait until the toxicology report comes back before you indicate anything? All right. And I've never spoken to any members of the George Floyd family, but it seems as if they did not want that type of narrative to be out. Because remember, I told you is that when these pieces of information come out, they don't just come out to the public, but they come out to potential jurors. All right. Jurors, if the defendant decides to have a jury trial, potential jurors are reading all of this information, and so the trial is beginning even though it has not stepped into a courtroom. All right? So now you have the second autopsy that has come out. And the second autopsy is saying that George Floyd did die from asphyxiation. Okay? So what does that mean? What that means is, one, the autopsies, now we have 2 points of view from legal experts. We have the county medical examiner, and then we have the independent one. It depends on what the judge is going to do, because remember, we have not even had a case assigned to a courtroom. So what that means is that the judge can try and have a hearing to determine which autopsy are you going to believe? Which autopsy is going to be believable? Which autopsy goes through the expert recommendations and the accreditation? We talked about that last week, because even though these are doctors, they still have to be subject to the same professional and legal standards as anyone else as it relates to an autopsy. Okay, so if there is a jury trial, the judge can do a couple of things. The judge can only use one autopsy, or the judge can decide and present to the jury, or have allowed presented to the jury, both autopsies. And then the jury has to decide which one they're going to believe. Okay? The other thing that I want you to know, and this is as it relates to every piece of evidence, is just because pieces of evidence are admissible, meaning that you can consider them, it does not mean that they automatically carry weight. All right? I will say that again. Just because pieces of evidence are admissible does not mean that they automatically carry weight of credibility or believability. So what do I mean? What I mean is that if a coroner decides to testify under oath that the cause of death and the manner of death is X, Y, and Z, the judge and the jury, despite all of the documentation, despite all of the evidence, despite all of the testimony, they do not have to assume that the credibility of the coroner is correct, and they do not have to give any weight or any believability to that report. Just because an expert testifies does not mean they automatically bring with them believability or credibility. That is still a determination for the jury or the judge. So the expert can create the documents, either Hennepin County, who did the autopsy, or the independent coroner from New York, I believe, that said that George Floyd died from asphyxiation. What can happen is that the judge can decide, jury, you can decide which autopsy you're going to review and which one you're going to believe. Or the judge can say, I get to decide. If it's a bench trial, which means that the judge makes a decision, the judge can say, okay, I will have both autopsies submitted to me, and then I will decide which autopsy I believe. Okay, so yes, while it is ultimately, well, I should say, as of right now, is it a good thing that there has been an independent autopsy? Absolutely. Does it mean that it is a slam dunk in terms of proving that the direct cause of George Floyd's murder is the police officer? No, not in my legal opinion. Okay, because the defense, remember, everything that has been happening has been on the prosecution side. The switching of the prosecution from the local level to the attorney general, the first autopsy report, the second autopsy report, all of that has been happening on the body, on the side of the body who is bringing charges against the officer. The defense has not done anything yet. So the defense, I predict, is now going to come in and do one of two things. Either Chauvin's lawyer is going to, one, say, let's believe the autopsy of Hennepin County, or two, they are going to have their own independent autopsy. Trust me when I tell you, these are the two options, okay? The defense, the police officer, is going to either, one, they're going to say believe the original report, because if you believe the original report, then it is a combination of issues and reasons as to why the officer is not as liable or as guilty for the murder of George Floyd. If the defense goes with option 2, which is to get their own independent autopsy, then what you're going to do is now you're going to have 3 autopsy reports. Now, I personally do not think that the defense is going to hire their own independent coroner, because it's very expensive. Not that he don't have the money, because do believe there are crowdfunding sources that are paying for his defense and everything that he may need now. You may not hear about it, but trust me, it's going on. All right. So if the defense decides not to hire their own independent coroner, they are going to try and rely on the first report, which breaks the chain of causability, which breaks the chain of the officer being responsible for the murder of George Floyd. Okay, so I hope that we understand that. I'm just going to go through and see now if there are any questions, because like I said, I don't want to be before you long, and I did my response without, any type of preparation, like I did last Friday. So I'm just going from the top of my head. One question is, what is the procedure? Not a question on here, I don't think. But one question is going to be, okay, what's the procedure for determining which autopsy you're going to believe? That I don't know. I did have, until my computer cut off, there is a Minnesota statute that talks about how autopsies are to be conducted in the state of Minnesota. But when I reviewed it, it did not talk about what happens when you have more than one. All right. So let me see if I can see anything. Are you all still with me? Can you hear me? I'm just going through. Hello, 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 everybody. Hello, 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 hello. Yes, hello, hello. They need some Chatal, don't they need some Markham prosecutors? Because if we was down the street, this would be a whole different thing. Okay. Shout out to Chatal Thikar, who was one of the Markham prosecutors that I was in the courtroom with, and we would go against each other like cats and dogs, because we both believe in justice. We just represented different perspectives. Okay. Sounds like, let's see, it's from Professor Chamberlain. Sounds like Minnesota PD is working really hard to try to turn public opinion against. Well, yes, because think about it, in that usually the police and the medical examiner are on the same side. That does not mean that the medical examiner is writing particularly to save someone. But in this case, you could tell by the language, the tone and the tenor of the medical examiner, that they were putting just enough out there for you to now start prosecuting not Derek Chauvin, but George Floyd. And that is something that always occurs. Think about with the case of when Laquan McDonald was murdered. There was a part in the trial where the focus was not on so much his killer as much as it was on him, which if you are articulating a defense of self-defense and you believe the reason why you did this was because you believe the decedent did that, then now you're going to go into his background, and now you're going to go into what he was doing beforehand. Okay, these are just tricks of the trade. So now you have the person saying, okay, what could be possible intoxicants? Why are we even talking about that? It's because you have to spin a narrative, and this is your opportunity to talk to potential jurors without any type of gag order, which is a legal doctrine that prevents people from talking to the press. Okay, I will be surprised if one does not come down pretty soon. The judge, whoever is going to be assigned to it, can say, you know what, y'all just stop talking. Okay, because you're talking to potential jurors. All right, let me see if I have any other questions. I see a whole bunch of people. Yes, autopsies are very expensive. Okay, you're welcome. We hear you. Yes. Okay, so in conclusion, because you know I'm still a teacher. In conclusion, does this autopsy, the second autopsy, automatically mean a win or a legal slam dunk for the family of George Floyd? No, it does not. What it does is it now gives the judge and the jury, whoever is going to determine whether or not George Floyd was murdered by Derek Chauvin. Whoever decides that, a judge or jury, they can either, one, they can completely decide that one autopsy is better than another one, or two, they can leave both autopsies in and allow the jury or the judge to decide which one is going to be believable. But as I said earlier, just because there is evidence, videotapes, statements, body cams, that does not excuse the rules of evidence. That does not mean that just because you have now jumped over the hurdles of admissibility that you have now won the fight of believability. Okay? Admissibility and believability are two different things. Just because something is admissible does not mean that the fact finder, the judge or the jury, has to automatically believe the expert opinion. All right? So, in short, we're in for a fight. It'll probably be a long one, while it may be a little quicker than regular murder trials. And when I mean regular murder trials, is usually you have at least a year of discovery, where you are subpoenaing, if that's the word, photographs. You're talking to medical examiners. You're going to the crime scene. You're trying to see what is the physical outcome of a person's death. You are looking to see what is the I'm trying to say because like I said, I had not prepared to come in front of you. You are looking to see what is all that there is to know, because when we start this trial, it is going to be a very publicized trial. Think about Jason Van Dyke and the murder of Laquan McDonald. Although we had the 16 shots that killed Laquan McDonald, and although you had an arrest, it was a while before you had the trial. So we need to be able to sustain and keep our focus. We have to pace ourselves. Trials like these, they are not a sprint, they are a marathon. And we have to make sure that we are still pressing with the issue of abolishing systematic oppression, legalized mistreatment of people of color, black people, brown people. We have to make sure that folks ain't slick. Now, we don't live in Minnesota. However, what happens in different states can affect our state in which we live. So we need to keep our eyes on the prize. We can't get dismayed or dissuaded because it's not happening as fast as we like. Because remember, we do want, I'm presuming that we do want a verdict, a finding of guilty, but what we don't want is one outcome that is either subject to appeal, or we don't want one where the police officer is not held accountable at all because we rushed to do stuff. Okay? Ellison keeps trying to get people to understand that this won't be a speedy trial and why they wouldn't want that. He's trying to manage folks' expectations and help them see. Yes, it is exactly that. I just said that, Carla, is that you don't want a speedy trial on this. You want to go through every piece of evidence that exists. You want to try and make sure that that evidence rises above the limitations or rules of evidence, meaning you want to make sure that once you submit, stands on its own face, and you also want to make sure that no evidence is stricken because you were so cocky or assertive or quick to want to give someone or the public the ability of saying, okay, we got him, now we arrested him, now we charged him, now we're trying him. It does not work like that, especially in a murder trial. This takes time. So drink your water and pace yourselves, okay? Professor Chamberlain, I missed the part at the beginning when you mentioned possibility charging. How they might be able to, okay, so how might charges be able to be increased? Is if the Minnesota Attorney General says, you know what, we looked at this evidence and we've taken into account both autopsies, and we believe that Derek Chauvin should be charged with first-degree murder, which is premeditation and intent, or second-degree murder, which is intent but no premeditation. What Derek Chauvin is charged with now is third-degree murder, which is no intent, no premeditation, and second-degree manslaughter, which is he was negligent in his duties. All right, let me just go through. Okay, hey, everybody. Hey. All right, so, hey, Shay, how you doing? All right, so that's it. That's all I got. I just wanted to come on real quick. Like I said, my computer has no energy or power. All of what I've explained is in here. All right, so, but just be on the watch. That is the biggest development. I will try and come on as often as I can to give little tidbits and little explanations. And please understand, hey sis, how you doing? The next full episode that I will do will be the murder of Breonna Taylor. All right, and the reason why I haven't done it now is for a couple of reasons. One, because although that happened preceding George Floyd, the questions that I got was about George Floyd, excuse me. So I did that first. The second thing is that there are too many black women whose death has gone unnamed, unprosecuted, and not discussed. And I want to do this sister justice by bringing her name, Breonna Taylor, by bringing her name before us to remind ourselves that, yes, it is not a contest about, you know, who is being killed or what have you, but by the fact that this outrage is not, or in my opinion, should not be relegated to a particular gender, okay? Black women have been getting killed just ridiculously. Trans women have been getting killed ridiculously. And if we are in June, the Pride Month, we need to start standing up, and we do not need to be distinctive in who gets justice and who does not. All of these individuals should be getting justice, period. And so the next episode is going to be talking about Breonna Taylor and talk about how there have still not been brought any charges for her murder and what are the options for prosecutors. Okay, so be also ready. Once I am ready with that, I will let you know. Feel free to share this video on social media platforms, and I will talk to you all later. Okay, I hope I have answered all your questions. If not, you can put in your comments after I go off live. You can state or ask what you want, and I will be here to answer it as best I can. All right, thank you all so much. Please stay safe, be safe, and manage your expectations about this case. It is a marathon. It is not a sprint. All right, you all take care. Bye-bye.